Okay, so I'm starting a little bit early hi, Linda. Just to make sure that for those of you, hi, Joseph, if you have any questions ahead of time, one phone call in listener. Hey, George, always good to see you. Um, anyway, I'm a little bit early. I'm a minute early, but I think that we're going to start filling up here pretty quick. So what I'd like to do is sound check. Somebody tell me we're okay. Hopefully, I like this little computer. And I'm going to go ahead and get started. And everybody else can join us when they're able to. I'm going to bet that's George. George, you're awesome. Thanks, buddy. Thank you, man. Good to hear from you too, by the way. Good interaction. And then I think you probably have left me with something to do, and I can't remember what it was, but I'll get back to it as soon as I possibly can. It's been a busy day. Needless to say, my day a lot of times is filled with lawyers. And I was just commenting to Linda that, and knock on wood, I was just commenting to Linda whenever a lawyer calls me, it usually means they want to give me money, which is so rare in our industry. So, I'm a big risk management guy, as you all know, and kind of my goal is to keep you out of trouble. I don't think this business is that difficult, but I think we can make it pretty complicated. So let's go ahead and get started. And I'm assuming that you can see the screen. Please move this window away from the, oh, you know what it is? Because I do another class in the evening, and after this, it's a live class, and it frequently, let's see, hide presenter view. I think that's that one. Okay, that should work, right? Okay, so you should only be able to see that screen and just the one screen and not the duplicates. And thank you last time, George called to my attention that you were all seeing several screens. So anyway, thank you all for being here. Hi, Serena. Serena, you show up as a Samson SMG 930V. So for the savvy people among us, hopefully they don't know how to hack into your phone. So anyway, thank you all for being here today. Let's go through this part really fast because we don't have a lot of time to cover what we're going to cover today. So let's get started. This is where we are. There's my contact information. I'm proud past president. Can't even tell you what a thrill that was. I don't know where the year went. Here's a bunch of credentials. If you want me to email them to you, I'll send you my CV. As I said in the very beginning, I'm talking more and more with attorneys. I had another call today, and apparently now they're fighting for me. And I'm not that bright, folks. I don't know. I guess maybe I just tell a good story, but I'm excited to help you in any way that I can. And that's usually why they're calling me, because somebody, one of us is in trouble, one of us is getting sued. And so we'll talk about, I do a lot of trial work, but as an expert, not as an attorney. So I'd like to first thank the association, of course, Don Tanner, our chair, Rocky Rockhill, our vice chair, Jane, who is just wonderful beyond words, and David, our staff backup. God knows he's the one responsible for editing all of this so that I still continue to look good. Okay. And I say that with tongue in cheek, but I'll tell you, sometimes it's like, David, can you take that out of there? That did not sound good. So anyway, this is live. Okay, folks. So we are on Wednesday. I can tell you what day it is when I can see my other computer. My other computer says we are on Wednesday, March the 4th at 1 p.m. So if you're hearing this at a time other than that, then you are watching the tape version of this. And thank you so much. I had the nicest email. Who was it from? One of our listeners who was so appreciative of what we've been doing, and I'm going to send you my RPA. We have a template on the RPA. I'll send you the draft 9 if you want. If you want draft 9 of the RPA that they're contemplating right now, I think as a body, I think our San Diego Risk Management Committee kind of shot it down. And again, our risk management committee are all some of the brightest real estate attorneys in the industry, big brokers, little brokers. I mean, it's a big deal. And they just say, you know what, nice try, but it may be a little confusing, more confusing and not really able to help. So if you want to copy that, let me know. I'll send you a copy of that. So I'll send you a copy of the new RPA draft number 9. I'll send you our current template with Linda's permission. I will send you our template on the RPA. Just let me know. Today, we're going to be talking about the RLA. So we do that too. So we will be talking on subjects that are going to appear to be legal. I am not a practicing attorney. I do a lot of trial work. Again, I testify as an expert. What is the standard of care? Did you do what you were supposed to be doing? And if not, did it matter? Can we do it differently? That kind of thing. And so those are the things that I get called out for. Our conversation is not intended to be a substitute for that of your broker, nor for that of your attorney. Please consult with them as appropriate. I'll be the first one. If you don't have an attorney and your broker doesn't have an attorney, or you're not represented by your broker or whatever, then let me know and I'll refer you to some of our brilliant attorneys on the risk management committee. Everything I know about real estate, I learned by virtue of my association with the association. Get involved, folks. It's the only way you're going to get all this stuff. You can learn a transaction at a time. We call that learning by trial and error. You make an error, you go to trial. That is not the way to learn real estate. You need to be constantly learning new things. And if you're not learning new things constantly, then get more involved with your association and let's get you up to speed, okay? It's important. Our discussion today is live. If you want to pull up the tape version of these, then it just means you can't ask questions, but it's obviously the same thing, maybe with a little bit of Photoshop on me or makeup, right? Makeup. So click on sdar.com, go to education, drop down to webinars. Currently, these are free. We're going to probably start working away from free, but free to members, but not free necessarily to the public. So, but for right now, it keeps on going. We want to do it. We're doing a community benefit. That's what it's all about. Okay. So, please, we are in the live version today. If you would give me your feedback as we go along, I'd love to be able to talk to you about things. We are going to be talking about the residential listing agreement. You are going to have questions. Please let me know what those questions are. Upcoming sessions, we're working on zip forms will be tomorrow. So the first Thursday of the month, from 10 until 11 in the morning, we will be speaking about zip forms. And if you have any specific parts of zip forms that you want to talk about, let me know, and I can incorporate that into our conversation tomorrow. Last month we covered kind of the surface of things, but that's a fun subject for me, and I am on the customer advisory board for Lone Wolf, which is the group that just bought ZipLogix, which is zip forms. Okay, so any feedback that you have would really be beneficial. Today, here we are, RLA. When we get done with the RLA, then we're going to go into the BRE. And all this is intended to cycle every quarter. So that's where we are. That's going to be every Wednesday from 1 until 2:15. And then tomorrow we're going to do the RPA in the afternoon. We're going to do from 1 until 2:15. We're going to attack another paragraph or two. You will certainly know the nature of the document. It doesn't matter what they do at the state level, folks. Whatever they do, you're going to understand the principle behind the paragraphs and the words that they're using and why they're doing that. Really, they're not doing much on the state level except shuffling things around. So for you, this is where you need to be. You need to be learning these things, okay? So if you have any webinar subjects you think would be of interest, please let us know. Send us an email, education@sdar.com. What a great group, I'm telling you. These people just all they think about is how can they give you more benefit from your membership. That's all they think about. So and thank you to the committee. They have a great committee, probably one of the better attended committees at the association. And then they all got in there thinking they were going to learn new things, but really what they're there to do is learn. We're there to learn from them. What kind of input do you want? What kind of things do you want to see from your association? So that's it. There's my contact. If you call me, I don't know where calls go. Email is always best, right? Kevin@Burke Real Estate Consultants with an S.com. Or if you send it to education@sdar.com, it will get to me. And we will get back to that slide later, just so that we can carry on. But I want to get into the subject matter for today, and it's a doozy. So we got a lot. So let's take a look. Hopefully you can see this agency relationships. Yes, you should be able to see that. Let me see, who did I lose? I lost somebody. Okay, I don't know who I lost. Okay, all right, something wrong with the program. Let's talk about agency relationships. Now it's interesting. I tell people, the time to learn all this stuff is when you've got some free time. The time to learn is not when you're sitting in front of your client. Your client says, what does this say? So, we're going to try to keep it simple here, but I'm going to tell you, agency relationships are the toughest thing. I have yet to meet a broker, and I'm going to quote Robert Muir, who's just a brilliant attorney on our risk management committee. And Robert says, I've yet to meet a broker who could explain agency to me. That is a scary thought. I mean, really scary, since it's a principle that goes across the entire country and it's everywhere. And yet, he says, I just haven't found anybody could explain it to me. And so here we go, right? Okay. So we're going to talk about those agency relationships. We're going to talk about the work involved in this. First thing we're going to talk about is the disclosure. We're going to make the assumption when we have it, and again, this is my listing agreement, right? So we're going to have the assumption that you have given to the seller prior to signing the listing agreement. Remember, the law says as soon as practicable. Okay. The disclosure regarding real estate agency relationships, it just says it all. All right. If you don't understand the concept of agency, why don't you read that form? Fascinating reading. I'm telling you, I mean, for me, it's fascinating. I'm sorry, it might not be fascinating for you, but I was asked by CAR probably 25 years ago to proof page 2 of that document. And I'm sure that most of us have never read it. I had to proof it. And I found like one mistake on the whole document, and that might have been the start of my career proofing work for attorneys and things like that. So, and I'm proud of that, by the way. It really makes me feel good that I can actually accomplish something. But you absolutely need to be able to confirm that you have given the agency form to your client, and this just assumes that you have. All right. And that's a real powerful assumption. Okay. It's very powerful that you have given that agency disclosure form. If you haven't given the agency disclosure form, I have seen cases where the Department of Real Estate has taken commission away. I saw a case where they took it away just where the lack of an agency disclosure was found right before closing, and they still took it away. They said it's just way too late. You need to make that disclosure right prior to committing conduct that constitutes agency. And that's the important thing to remember. Okay. So very clearly, and I teach this in several states, very clearly, if you're taking a listing agreement, you are there. Okay. You have to make this disclosure. So that's one of the reasons we added it to that like mini template. The CAR added it. It's the very first form you ever have a client sign. It was, for those of you who've been in my college classes, that's number one test question other than what business are we in, right? And the number one test question is, what is the very first form we ever have a client sign? And that's going to be my agency disclosure. Okay. And that's the reason behind all that. So it's a big deal. Paragraph number B talks about seller representation. Broker shall represent seller in any resulting transaction except as specified in paragraph 3F, which was, if you remember 3F from before, 3F discussed that they had an obligation to work with another agent at the time that you took this listing. So, but the seller is agreeing to allow you to represent them. And that's what this paragraph is. So when people call me on the phone and they say, where does it say in the listing agreement that the seller has to let you represent them in a real estate transaction? And I go, well, let's take another look at, why don't you go take a look at the RLA, the residential listing agreement, look at paragraph number 9. And I think you might find the answer there. Okay. Paragraph number C. Now, remember, when we create the listing agreement between ourselves and the seller, remember that we don't know if we are going to be single agency or whether we are going to be dual agency. Okay, so at the time we take the listing, all we know is that we're single agency. We don't know where that offer is going to come from, what broker is going to represent that buyer, and we don't know whether or not it's going to be dual agency. So we need to have the seller's consent to maybe have dual agency. So again, depending on circumstances, may be necessary for the broker to act as an agent for both the buyer and the seller. So in California, at least, we allow that to happen. We allow dual agency. In some states, we don't allow it to happen. And certainly if you're an attorney, you can't be a dual agent representing conflicting clients. It's a conflict of interest, so you can't do that. So that's why the law field has a hard time with us doing this. So please treat that with respect. Be very careful about your representation. Make sure that you're doing your job the right way, because you know what? It's a benefit to being able to do that. Okay. So broker shall, as soon as practicable, there's the language off of page 2 of that agency disclosure form, as soon as practicable, disclosed, and I'm not sure that's a word, by the way. I think I looked it up and I couldn't find it. Disclose to the seller any election to act as a dual agent representing both seller and buyer. So obviously you need to disclose to the seller, prior to being a dual agent that, hey, guess what? We're on our way into dual agency. Now, some states require consent. So literally, it's not in California. In California, it doesn't require, here's your consent. The seller is agreeing to this here. But in other states, those states actually step up and say, you know what, you have to make a written disclosure and you need to get seller's consent to be the dual agent. Otherwise, they're going to have to go find another agent. How'd you like that, right? Okay, so it's not here yet. It could be coming. Okay, if a buyer is procured directly by the broker or an associate licensee in broker's firm, bingo, dual agent, right? Seller hereby consents to broker acting as a dual agent for the seller and the buyer. In the event of an exchange, okay, same thing, because now we're going to have that all happen. Okay, disclosure to all the parties. Seller understands and agrees that a dual agent may not, without the express permission of the respective party, disclose to the other confidential information, including but not limited to, the lawyers wrote that. Anytime you see that language, lawyers wrote that. Facts relating to either the buyer's or seller's financial position, motivations, bargaining position, or other personal information that may impact price, including the seller's willingness to accept a price less than the listing price or the buyer's willingness to pay a price greater than the price offered. Okay, so now, by the way, these are specific questions on state exams in other states. Okay, specific questions, and in some states there's information that you absolutely may not disclose, and then they have a second set of information that you may not disclose at the instruction of the party. So you're going to the breakdown of that is going to be twofold. Okay, so and except as set forth above, a dual agent is obligated to disclose known facts materially affecting the value or desirability of the property to both parties. So you all recognize that from the Strasburger case, and so I talk about that case all the time. That was a landmark decision, and it ended up requiring us to make sure that the seller makes those disclosures. And I've often said to people, what if the seller discloses something to you, tells you something, and not to tell the other party? And if you're not going to tell the other party, then I might have to, or I might have to not take the listing. It may very well be that I might be conflicted. Okay, so those are important points, and certainly I'm going to tell you important points of law, and I can assure you that they are enforced. So any questions about any of that material so far? That's 9A, B, and C. Seeing none. All right. Confirmation. So, it's interesting. I was having this dialogue with the risk management committee. I wrote a letter today or a note today on, actually I wrote it a week ago. It took me a week to get it to them because I needed to reread it a couple times. But, about we used to have a paragraph, currently you have a paragraph in your listing, in your purchase agreement, paragraph number 2, that talks about agency. It talks about the confirmation of agency. And in that form, it says, we're just going to assume that you have disclosed agency, that the buyer's agents disclose agency to their buyer, that the seller's agent is disclosing agency to their seller. We're just going to assume that. That's paragraph 2 of your residential purchase agreement. Okay. It used to be paragraph 26 or 27. I'm going to have to dig out my old forms, but it used to be 26 or 27. And Veronica made a great comment in one of our meetings, and it came up later on by Commissioner Bell, that nobody was ever filling it out. And it's because it was so far away from the action part of the contract, and everybody just kind of skipped over it. But that was that part. So, by process of law, you must disclose agency, right? What I said a second ago, prior to committing conduct that constitutes agency. So clearly before you take a listing, clearly before you write an offer for a buyer, very clearly before you do a buyer representation agreement, all right? Very clearly you have to have that disclosure made to your party, all right? Now, at that time, you only know that you are single agency. So you don't know that you're going to be entering into dual agency. You don't know, you haven't confirmed who the agents are for all of the parties. And that's the important part about this. So now we get to D, paragraph number 9D, that says, broker shall confirm the agency relationship described above or as modified in writing. Veronica says, be prepared to defend the fact that you made the disclosure, and you need to do that in writing, okay? Because, your word against theirs, folks, I'm going to tell you, in my experience, your word against there in court is not going to fly, all right? You are the professional. You have forms available to you to be able to make those disclosures and to confirm that you've done them, and you are not going to be doing that. You have to do them in writing. You have to do that agency disclosure form prior to or concurrent with seller's execution of a purchase agreement. So as I just said, okay, so now at the time of the listing, I know that I'm the single agent. I'm a single agent for the seller. The broker's the single agent for the seller. Okay. So I don't know who the buyer is going to be represented by. So I don't know, but I know I have to disclose single agency. And then later on, I might have to confirm that it's either single agency or dual agency. And that I'm going to do in the purchase agreement on paragraph number 2. So that great big long thing about, it used to be paragraph number 26. We weren't doing it. We weren't confirming agency. And I'm sorry, the law requires it. You have to confirm the agency that everybody is. Okay. So as I've said before, you must disclose the concept agency when you first work with the client, and then you must disclose, other than the concept of agency, you must confirm agency in the purchase agreement with the parties. Okay, critically important. All right, very, very important. Okay, let's take a look at paragraph number E. Oh, first of all, any questions? No, seeing none. Paragraph number E, potentially competing sellers and buyers. So seller understands now. This is your PRBS. Some of you remember it was our DA form, right? Our disclosure, regarding possible representation of more than one buyer or seller. We changed the name to the PRBS. Okay. Seller understands that broker may have or obtain listings on other properties, and that potential buyers may consider making offers on those or purchase them through that same broker. So in other words, we might have another listing right in your same neighborhood. If you're a farming agent, if you like to do farms, you like to work on a geographical area, the chances are pretty good that you have another listing somewhere nearby, right? Or better yet, your broker has a listing somewhere nearby. You're with a great big brokerage firm. Chances are very good that you have one. And this came out of a lawsuit against a large brokerage firm where the two agents that had the listings weren't even related to each other. They were way apart in distance, but they were under the same broker. Okay, so same broker. So therefore, we had to get the permission of the seller. Now, again, not statutory. This is contractual. The agency disclosure is clearly statutory, but this competing buyers and sellers or sellers and buyers is going to be contractual, and you're going to be doing that, making that disclosure to protect your broker. Frankly, let's be nice to our broker. Okay, so we may have listings in the area, we may represent buyers in the area that may write competing offers on multiple properties, and the property same or similar to the seller's property, and now we're going to need your consent to allow us to do that. Now, I don't know. The court didn't tell us in that case. The court didn't tell us how close those properties had to be, but so from terms from the seller's perspective, I don't know. It could be, what, a block, maybe 5 blocks, 10 blocks. But since the court didn't come down and tell us the distance, we're just going to get the form signed so that it covers us under any distance. Okay. It's just going to have to be one of those things. And then when it comes to competing buyers, so on the flip side, when you're writing your offer for your buyer representation agreement, you're doing your purchase agreement, at that time, you're going to get your buyer to sign one, because you don't know if you're someone else within your brokerage firm. Remember, everything is under the broker, under the umbrella of the broker. Somebody else in your brokerage firm is actually going to write a competing offer that's going to compete with this buyer, and supposedly you're conflicted. And I don't care how big your firm is, the law is clear that if you two people under the same brokerage are writing offers on competing properties, then you know what, you're going to run afoul of this. So we don't want that to happen. Okay, so the seller in our paragraph E here, seller consents to the broker's representation of sellers and buyers of other properties before, during, and after the end of this agreement, and the seller acknowledges receipt of the PRBS form. Okay, everybody good with that? So you have those two forms. Those are going to begin your litany of disclosures. Your agency disclosure is going to be the first form you're ever going to have your client sign. I would recommend the PRBS be second. Third form that you're going to see in your little mini template that CAR created, of course, is going to be your wire fraud advisory. And you know what? With the new RPA, it's just going to be a default in the under the addenda and advisories. And frankly, it should be. It's already included in your purchase agreement mini template. Those things. Wire fraud is on the rise. It is not going to get less. Only a couple of years ago, the FBI was saying that we were 4 to 6% of a target for these people. Today, I think we're at 20%. I mean, that number's gone way up because it's a lot of money. Okay, so let's be aware of that. But your agency disclosure, your AD form, first form you ever have the client sign. Second one is going to be my PRBS. Everybody good with that? And that should cover us for paragraph number 9. Okay, no questions? Seeing none, let's talk about paragraph number 10. All right, number 10. So number 10 talks about security, insurance, showings, audio, and video. All right. So this is a hot subject. All right. Why? Well, for those of you, who are out there active in the industry, you know that there's a lot going on. I get a kick out of the cases that we were getting where the buyers in the property discussing, the negotiating of the offer with their agent and the sellers monitoring the whole conversation. It's like you need to tell your people that in this day and age, there isn't a whole lot that's secret. You go into somebody's house, you don't know if they've got video devices watching you, you don't know if they have audio devices recording you. So we want to make sure that in this scenario, when talking to the seller, we need to make these explanations to the seller, not like we're trying to give them ideas, right? But sometimes it ends up happening that way. So broker's not responsible for loss or damage to personal or real property or persons, whether attributable to use of a lockbox. Okay, so lockboxes are just the way of life. I've often said if somebody wanted to break into your house, it'd be easier for them to go through the window than it would be to get into one of those lock boxes. The central lock boxes are just, I don't know. I've never heard of anybody breaking into one. So that'd be a first. If you've heard of somebody, let me know who it is. I'm like, wow, I'm impressed. Okay. I've often said that, it'd be easier to throw it through the window to get access but of course it's attached hopefully to something, although I have seen agents not attach them to things, but all right. Okay. So whether it's through a lockbox, showing the property or otherwise, because remember, we have those problems with open houses, where the bad guys come in twos and we make the mistake, we're there alone, right? I've counseled you from the beginning, always have another person with you at the open house. The bad guys like to split you up. And so, we want to watch out for that. So I did an interview with Channel 8. They were, asking me, well, what are they doing in the house? Well, they're going upstairs. They're going through the medicine cabinet in the master bedroom. And what are they taking? Well, they're not taking your cholesterol medication. They're taking your mind altering things, your propanols and those kinds of things. And that can be pretty deadly. And they can, by the way, they have a street value. So, that's one of the reasons that they're doing that. So we need to make sure your seller's aware of these things. Third parties, including but not limited to appraisers, inspectors, brokers, prospective buyers, may have access to and take videos and photographs of the interior of the property. And we're going to talk about property images here in a second, okay, of the interior property. Seller agrees, and here's a list. 1, take reasonable precautions to safeguard and protect valuables that might be accessible during showings of the property. I have gone into houses and seen people's money clips on top of dressers, photographs that you probably don't really want the public to see. And guess what? Then there's people who are taking pictures of the photographs, stuff like that. So listen, use your discretion. Tell your seller, you need to put those things away. Certainly a loaded weapon, not a good idea. So we want the seller to take reasonable precautions, and we want them to obtain insurance to protect against those risks. They need to have insurance, right? If they don't have insurance, not everybody has insurance on their homes. And if they do, they may only have hazard insurance. Do they have personal property contents insurance? That's very, very important for those exceptionally expensive items. So like a Rolex watch, for example, do they have insurance to cover the Rolex? And so, those kinds of things are usually going to require a rider on your insurance policy. It's not, I've got insurance, so it must be covered. They're going to require a rider. Weapons, if you've got guns in excess of a certain value, then they're going to be, need a separate rider for that. What happens if you have a tenant in the property? So we had a claim. A tenant submitted a claim that they were missing their Rolex, and they spelled Rolex wrong. I mean, they were just kind of trying to see what they could get away with, but at the end of the day, does the tenant have insurance for those things? And that's why you want to make sure you use that key safe lockbox addendum. Okay. All right. Broker does not maintain insurance to protect seller. A lot of our sellers think that we have insurance to cover them. No, we don't. We have E&O insurance, errors and omissions insurance. Now your broker carries other insurance. They should be carrying general liability insurance, and obviously they're carrying workers' comp. So they have these other insurances that they have, but that doesn't cover the seller's personal property. So the seller needs to be aware that they need to get insurance to protect themselves as well. Okay. So persons visiting the property may not be aware that they could be recorded by audio or visual devices installed by the seller, nanny cams, hidden security cameras. I'm not so sure they're hidden anymore. I see them all over the place, right? Outside the house, inside the house. Okay. I mean, one of our brokers, super broker, he's got like 16 cameras, and he's got a whole TV set in his kitchen that covers all the various accesses to the property. So, I mean, it's amazing what people are doing today. Sellers advised to post notice disclosing the existence of security devices. Isn't that a shame that the seller has to post a notice to let the buyer know that they could be getting recorded in the seller's house? I don't know. I mean, there's that old argument about wiretap. Are wiretaps illegal? Not necessarily. They're just inadmissible, right? I mean, it depends. You can talk to your lawyer about that. Hopefully you don't have those issues. So do we understand security, insurance, showings, audio, and video? This is an important subject. So comes up all the time. Okay, no questions, seeing none. I'm going to roll us forward here, and well, we're going to wrap it here. So, okay, so let's take a look. Photographs and internet advertising. So, and this is going to dig in deeper than what we just talked about. So before we talked about audio and video, but now we're really going to get into this. Okay, this is going to be the deep part of this subject matter, and of course, I'm preaching to the choir. You know what I'm going to say. You're going to know this. You're going to be armed with this when you go out and the seller asks you a question. You know, our biggest fear on a listing appointment is that the seller's going to ask us a question that we aren't going to know the answer to. So all the answers are here. We make it easy, okay? So photographs and internet advertising. In order to effectively market the property for sale, it's often necessary to provide photographs. You've all heard the saying that a picture's worth 1,000 words. And you know what? It is, okay? So, you know, people look at pictures, even the whole concept behind some of our third-party aggregators, you know, Pillow and Gulia, you know, they've even said, we're just a marketing company. We're just here to sell people. People like to look at pretty pictures. That's a quote, folks, in our meeting, in my meeting when I was in the committee with Sandacor, you know, then they said to us, they said, we're not competing with you. We're just selling pictures. You know, people like to look at pretty pictures. So pictures are worth 1,000 words, all right? Virtual tours, other media to buyers. Okay, seller agrees or doesn't that the broker may photograph or otherwise electronically capture images of the exterior and interior of the property for static and or virtual tours of the property. So static being just a photo, virtual tour being a moving video, and others, okay, for buyers and other people. And we're going to talk about it in a minute, but those pictures are forever. All right. So again, you know, you got stuff laying around the house that you don't want to have show up on this material. And I'm going to tell you, now's a good time to put it away. Okay. You know, you have the Van Gogh on the wall, and here goes the camera guy going through going, wow, that's a really cool Van Gogh. And it's like, and then they see the signature, and now you're broadcasting it on the internet, and now you're making your seller a target maybe for a B&E, right? For breaking and entering, somebody to break into the house to try to steal that picture. And we don't want to have that happen. So we want to have this very real conversation with the seller, even though, you know, it's starting to look like, I'm on paragraph number 11, it's starting to look like I've been sitting down with the seller now for an hour and a half. And guess what? Remember what I said before? The time you spend with your client prior to marketing the property, the time you spend with your client at the time of the listing, time you spend with your client at the buyer representation agreement is worth all the time you're ever going to spend with them, because you know what? Now they get the part about why your service is so valuable, rather than just flying in there and having them sign a listing agreement and get out of there as fast as you can before they ask you any tough questions. How about you sit there, you spend time with them, and you go over all these forms, okay? All right. That's critically important. So is the seller going to allow that to happen? Are they going to allow you to take pictures? Are they going to allow you to have virtual tours? Don't just shine this on. Don't just put this in front of them and say, sign here, initial here, right? In the old days, we said, you know, press down hard, bottom copy is yours. Don't just do that. Make sure they understand what they're agreeing to do, okay? So we're going to look at otherwise electronically capture images of the exterior interior of the property by buyers and others for use on the broker's website. Hopefully you're doing that. A lot of your sellers are saying, are you going to market me on the internet? Are you going to put me on your website? Are you going to, you know, you're going to be bragging about all this traffic that you've got. So now they're going to say, okay, is my property going to be on there? And then, okay, do they understand the ramifications of that? Okay. MLS, absolutely. With the MLS, we're going to have, with the MLS, we're going to have pictures, we're going to have photographs. You can put up to what, 28 pictures of the property on the MLS, right? So, you know, that's a big deal, okay? People look at those pictures, okay? Other marketing materials and sites. Seller acknowledges that once the images are placed on the internet, neither the broker nor the seller has control over who can see them. Right? We don't have any control anymore. God knows if you're a member of SDMLS, you know it's going, those pictures are going all over the world. I mean, it's great marketing for you. At the same time, understand that maybe you don't want all that content, you know, those things that are in there, okay? So, or how long the pictures may remain available on the internet. And we know this for a fact. I get calls, you know, I was the broker for my own company. I gave the company to Linda. And you know, but I got those calls that said, you know, take my pictures down off the internet. And I'd go, who are you? And they say, well, I bought the property you had listed. And it's like, well, I don't have any control. Once we put that in the MLS, it goes out to the world. We don't have the ability to take it back again, at least not at this point. And I don't see anybody working on making that happen so that we will be able to take the pictures back again. I think that at this point in time, you have to understand, just like we learned in law school, right? You can't unring a bell. You know, once the bell has rung, it is rung and it's off. You're gone, okay? Kathy Merringer made a comment the other day, said, you know, the train has left the station. I just think that's great. The train has left the station. If you realize, you know what? Guess what? It's over. It's gone, okay? All right. So how long those images may remain available on the internet. Boy, that's a big deal. Seller further assigns any rights in all images to the broker and agrees to the broker now and agrees that such images are the property of the broker. Now there's your defense to the seller coming back later on and saying, those are pictures of my house, that I own them. And the answer is no, they've just given you permission. And that broker may use such images for advertising, including post-sale and for broker's business in the future. We're going to see how important that is for us in a second when we take a look at the property images agreement. And that is a document that we actually had people coming into our risk management committee to discuss that document. It's a pretty big deal. Okay. So, you know, are we getting permission? You know, what is our relationship with the photographer? What is our relationship as a broker with that other company? This document right in front of you is defining your relationship with your seller. And then you're going to see in a minute that your relationship with the photographer is defined by another agreement. And that agreement is between you and them, well, between your broker and them. And that document is going to reference this document. Okay. All right. It all ties together, folks. There's a reason for all of this. Okay. Let's take a look. Any questions on number A? Not yet. Okay. All right. This is dicey stuff. And again, if you're taking a lot of listings, you're probably having problems in these areas. You know, keep me in mind if I can help you in any way. But I can tell you that this is definitely ripe litigation. Okay. Paragraph number B, still under photographs and internet advertising. So in paragraph number B, seller acknowledges, 1336. Seller acknowledges that prospective buyers and or other persons coming onto the property may take photographs. So these are other people, buyers, tenants, whatever, videos or other images of the property. Seller understands the broker does not have the ability to control or block the taking and use of images by any such person. And listen, how you all know, if you've taken listings, you know how important this is. You know, I can't be there, you know, with, you know, buyer number one, the husband goes this way, wife goes that way, you know, whatever. They go in different directions. I can't be monitoring everything they're doing, although that's my responsibility, hopefully. But we're trying to shirk some of that burden and give it back to the seller and let them know that, hey, you know what? Can you put your toys away? I mean, it would be kind of nice if you did that. I know people that have some pretty impressive arsenals in their homes, and I got to tell you something, you'd never know it. You just wouldn't. You can go through that home and you would never know it. And that's what your seller needs to be thinking. Your seller needs to be thinking that they got something that they can't afford to lose, or they got something that could be dangerous in somebody else's hands. They need to make sure that those items are covered up and cleared. And cleared, of course, term, you know, not loaded or whatever, something that's put away. Okay. All right. That is really, really important. So the seller understands, and that's the language in this agreement, that the broker doesn't have the ability to control or block the taking and use of pictures. They're just going to take pictures. I mean, they're taking pictures with their phones. They've got hidden cameras. Heck, the seller has hidden cameras, right? Everybody's got a camera nowadays. Everybody's recording everything you're doing nowadays. So let's make sure that you've informed the seller. You don't have control over it. It's up to the seller, you know, to keep those things secured. So If checked, seller instructs the broker to publish in the MLS that taking of images is limited to those persons preparing appraisal or inspection reports. So the seller can actually give you an instruction that you put into the multiple listing service that says you're not allowed, the public are not allowed to take pictures. And so hopefully you'll have the broker that's showing the property will respect that. But this is the instruction from the seller. Okay. So seller acknowledges that unauthorized persons may take images who do not have access to or have not read any limiting instruction in the MLS. So it's possible, right? So the agent is supposed to tell, it's in the MLS, you put in the MLS, no pictures, right? And then the agent doesn't tell their buyer, or the agent ignores it, or the agent never read it in the first place. So the agent just showed up, and next thing you know, you got a whole great big conflict going on. So we want to watch out for that. Okay. We want to be really careful about that. All right. And I say all this not knowing whether or not, what I'm saying to you right now is going to bring me, if I'm going to be, if somebody's going to bring this into trial and say, well, Kevin, you said this. So the good news about me always telling you the same thing is that I'll be able to defend anything I'm telling you. Okay, so I'm kind of excited about that. It's really cool. All right, so seller acknowledges that unauthorized person may take pictures who don't have access, or who take images regardless of any limiting instruction. They could just ignore it, right? We said that. Okay, once images are taken and or put into electronic display on the internet or otherwise, neither the broker nor the seller has control over who views those images, nor what use viewers may make of those images. We just don't know. So do you understand how this is kind of an important paragraph for us in real estate, especially, we're not even at the emergence of video and audio. We are deep in it. Okay. We are just way deep in it. People are taking pictures. They're coming up with stuff, it's kind of like, you try to hide something, they're going to find it, that kind of thing. So let's put things away. Okay. Weapons, drugs, we've got this huge drug take back program going on, in San Diego, in fact, all over the country. And people are dying from this. So, please, make sure you secure the place, make sure you explain to the seller that these are serious issues for them and that they need to make sure that they are protecting their property as well as, as well as the fact that, the document is kind of intended to indemnify you, trying to protect you from a claim by the seller, because you're going to be able to say, well, this is where I told you all that. Now, if you haven't read it, of course, then you wouldn't know it was here, but I assure you your broker has read it. So, but that's not going to be good enough because your broker may not be with you on a listing appointment. Okay. All right. So these are important things to keep in mind. Let's take a look. Any questions so far? I'm going to go ahead. All right. So no questions on any of that. I'm going to dig into the, I need a new share for this. So I need to pull up the document that I wanted to show you. This is our property images agreement. The property images agreement came to us from the California Association of Realtors. It actually came out about 2 years ago. It's kind of interesting that this document would be come onto the scene 2 years ago, and yet I've talked to people that don't even know it exists. So my advice is that you use this document. Again, this document, as we're going to see in the recitals up at the top, is going to be made between the licensee and the photographer. Okay, so this is not, you notice there's no place on the seller for this. So remember what we said, that last document that we looked at, that document showed what our agreement is going to be with our seller. This document is going to, and that document referenced that we may have a separate agreement with the photographer. So that's what the property images agreement is. It's between us and the photographer, not between the seller and the photographer, not between the seller and us. Everybody got that? Important concept, okay? So we're going to date it. We're going to put the real estate licensee. You're going to put the firm name in there, please, and then the name of the photographer, whoever that's going to be. So, like I said, we had a couple of photographers come down to the risk management committee. They were very concerned about this document. But I think at the end of the day, after reviewing it, I think that, kind of lays the ground rules as to where everything's going to go. So you should be thinking about having this in your file when you're working with your seller, and you might even produce a copy of it for your seller. I don't know. Talk to your broker about that. Okay. So the description of the work. So the REL again is our real estate licensee, has engaged the photographer to photograph, visually record whatever they're going to do, cameras, drones, other technology. You're probably using drones by now. That's a big deal. Whatever, we're going to call all of that images, okay, for the purposes of using them as permitted by home sellers in connection with the real estate industry. So now we're telling the photographer that, you know, we're engaging you and we're going to be using these photographs that you're taking, and we're going to dig down into how deep we can go with that. Images shall be for the property or properties identified below. So you put the street address of the property. If no properties are identified, then from time to time, and then you know we have a form at CAR called identified properties. We're going to pull that up. You can put it on a separate piece of paper as long as you use the recitals from this agreement. So when I say use the recitals, I'm talking about using this top part, okay? So use that top part to reference it, all right? So that's paragraph number 1A. Now let's talk about B. B, this agreement shall continue until one of three events, okay? So, and it can be an and statement. You'll notice there's no or later. So until what? One, terminated in writing by either the licensee or the photographer. Two, delivery to the licensee of the images for the property, okay? Three, a certain date. So you can pick one or more, go for it, all right, by a certain date. But most people are probably going to check the second box. The first box is the default language, so it's terminated by parties, and you know, if it doesn't get terminated, then maybe delivery does it, or maybe we just specify a date, or we don't at all, right? Maybe we don't specify a date. Maybe we just say that it's good until it's terminated. That may be the way to go with that, okay? All right, okay, paragraph number 2, compensation and payment. The REL, the real estate licensee, agrees to pay the photographer in consideration of the services rendered by the photographer, one, as set forth in this agreement, so whatever that's going to be in here, or two, in accordance with schedule set forth in the photographer's invoice, okay, so, you know, bill me, or three, the total amount of X dollars, okay? All right, so that would be my compensation. Everybody good with that? We got to talk about compensation, okay? Let's talk about specifications. Okay, images shall be in a reasonable format and quality for internet and print media use. So you all know that that's going to be a different standard. Each one of those is going to be a different standard, right? Whether they're print media, you know, email, images tend not to be of higher resolution as a web page might be, or whatever. So we want to make sure that they are formatted, reasonable format and quality for internet and print media. So further specifications regarding number, nature, delivery, etc., if any, are outlined below. Let's talk about grant of rights, because this is where it's going to get fun. So grant of rights. So we're going to have a couple of scenarios here. So the first scenario is the photographer grants the real estate licensee. So now remember, this is an agreement between you and the photographer. So rights to the individual, to the images as below. Now we're talking about rights. So let's see what that looks like. A, an assignment. So in A, the photographer irrevocably assigns and transfers to the licensee all of the photographer's rights to the images, okay? Including, without limitation, copyright, whether now or later or whatever. Photographer agrees to cooperate and take all action reasonably requested by the licensee in connection with the assignment of the photographer's rights to the REL under this agreement, including executing all this other stuff, okay? And providing information regarding the agreement. Specifically, but without limitation, photographer agrees to assist in filing copyright applications in the U.S. or elsewhere if requested by the real estate licensee. Do you think this is the part that got everybody excited? Okay, so this is the part that did. It got everybody excited, okay? So that's the default language in the agreement, and that's the part that created all the heartache, okay? So guess what? You get it all, right? You know, because, you know, you have this happen where photographers come along and they take the picture, and then all of a sudden, you know, you only get the link for a year. You know, right? Because they don't want you using their pictures or somebody else using their pictures or whatever. And you know what? That's not part of the deal. So that's why this agreement might help you if that's not what you are intending, okay? Then the second part is an or statement. So remember what I always say, if it's an or statement, then it's either the above or the below. It's not an and statement. So pick your poison. If you leave it alone, then A applies, and that's probably the larger bundle of rights, okay? Or B, now we're going to get a license to use the pictures, okay? So exclusive license agreement, all right? So you're not getting a special license like a hunting license or a fishing license. You are getting license to use something. It's almost like an easement, right? The right to use the property of another. Well, in a license, that can be terminated. There's all kinds of things that can happen to that right to use. Okay, so photographer hereby grants to the licensee an exclusive worldwide royalty-free license. Okay, boom, there it goes. Remember, license is a term of law. Okay, including without limitations such uses of the images in connection with advertising real property, real estate services, and to authorize and sublicense such rights to third parties at the REL's discretion. So you put it in the MLS then sends it off to the third-party aggregators. You're not getting it back. It goes out. That's the way it is. Okay, but it is clearly a license. Rights shall include the right to sue. To that end, photographer agrees to provide any information necessary to repair all that. Okay, I've requested the licensee acknowledges in the last sentence there that the photographer retains title and ownership of the images. So you see the difference between the two. So 4A says it's yours. You're done. I don't have any more rights to it as a photographer. You get it all. B says you get the right to use it. And then that's going to probably contain some restrictions in time or some restrictions in use. So again, my reference earlier, that the link that they send you the photographs in a link. They're all trying to protect their product. They send you the photographs in a link, and that link is only good for a year or 6 months or whatever. And so you probably as a licensee don't want that. So you'd like to have A, the photographer might want to have B, and remember they also want to be able to use their work product to market how great they are at taking pictures. Okay, let's take a look. C applies to both A and B. Parties agree, or if checked, do not agree to grant the photographer a limited license to use the image for his or her own portfolio. So this is my example where the photographer gets to use them, but not outside of the realm of what they've been contemplated to do here. So, I mean, some of these photographers are spending serious money getting some of these pictures. And I know some of them that are flying around in helicopters. That is not inexpensive. And so they might want to be looking to protect that work that they're doing and at least get some future use out of it. Or they may take, I know that we're working with a photographer company that is taking aerial photos of areas just so that, our members can use them. And so those are kinds of things that, we need to be discussing who owns those pictures, what are the rights associated with those pictures. Okay. All right. So photographer and shall be restricted to photographer's own site or platform to promote its photographic services, nor the royalty or other consideration will be due to the photographer except as provided in paragraph 2 above. Here we go, paragraph 2 above. Everybody got that? Okay. All right. Page 2, and we're almost done. Most of this is just boilerplate stuff. Representation warranty. The photographer represents and warrants that it owns the title and all that to these pictures. No third party has any rights to any of these things. And you need to know that. Then the photographer has full right and power to enter in the agreement. Right. So, I love the way they put these forms together because they really do cover all the bases. Okay. And that's their goal, is to make sure that everybody understands this is the big picture. Photographer further represents and warrants that the licensee is under no obligation to credit the photographer. Wow. Wouldn't that be something if we had to put, ABC, photography studios on all of our pictures? That would be, kind of a nightmare. And we don't have to give them credit, and they're giving us that representation in here. Indemnity, the photographer shall or not indemnify, defend, and hold the licensee harmless from claims, including costs, reasonable, whatever that is, attorney's fees and costs, resulting from the photographer's material breach or third party claim of material breach, blah, blah. Okay, so you got all that too. So, are you going to ask the photographer to indemnify you? And that may very well be, what you want. Okay, all right. Let's talk about the relationship of the parties. So photographer understands and agrees that it is an independent contractor, whatever the state of California is calling that today, of the licensee, and nothing in this agreement shall be construed to create a partnership, joint venture, or employment relationship. Employment relationship, key word, okay, between the REL and the photographer. So we want to be careful that we're not only do we not want to do actions that make it look like they're the employee of ours, but we also want to state it in writing that we're not. that they're not our employee. Okay, lots of things going on with independent contractor employee relationships right now in the state of California. You don't want to get involved in that from a legal perspective. Additional terms. The validity, construction, and enforceability of this agreement shall be governed in all respects by the laws of the state of California. That's standard language. Constitutes the entire agreement, supersedes any prior oral or written agreements, parole evidence rule, right? This agreement may not be amended except in writing, signed by the respective parties. This is all the boilerplate. Failure of each party to enforce its right shall not constitute a waiver of such rights. Provision in paragraphs 4 through 8 inclusive shall survive any expiration or termination of the agreement. So it'll go on in perpetuity. Okay, broker identity and rights. If the REL, if the licensee is a salesperson or a broker associate, which is likely, conducting license activity under another broker's license, that broker, so responsible broker, some states call it broker of record. Linda calls it broker of record. Some states call it responsible broker or designated broker. That broker's name and license number is as follows. So here's the firm name, whatever that firm name is, and then here's the licensee number for that firm. Okay, if it's a corporation, put the corporate name in there. If it's a broker, operation, not a corporation, then put the broker's number. The DRE will issue a corporate license number for corporations, so that number would go in there, okay? As between the licensee and the broker, rights to images granted on this agreement shall be addressed in a separate written agreement between them. So, we call that the Office Policy Manual. And I like that, as I was reading it, when they first came out with the form back in 17, okay, I like that because it references that you actually have an agreement with your broker. Now, here's the deal, folks. If you don't have a written agreement with your broker, then I'm going to tell you, you probably forgot. But if you really don't have a written agreement with your broker, that's against the law. So the DRE does require that you have a written agreement with your broker. And these are the kinds of things that should be included in that. So our office policy manual is, I think, about 100 pages long. I mean, it's pretty extensive. And if you need help with creating one, or if you don't have one, I can give you some advice on how to do that. Non-legal advice, of course. All right, let's take a look at paragraph number 10. I don't have any questions yet. Let's take a look at paragraph number 10. So MLS rules. MLS rules generally contain restrictions against and have the right to impose citations on its participants. That's you. In instances of reuse of images by subsequent real estate licensees. Excuse me. If you've ever had it happen where somebody else copied your picture, I know I've been involved in, I've had, oh my God, I had a client who was an attorney who sued another agent for using a picture that I took. And it's like, anyway, it's like, please don't use other people's pictures. I mean, that's their work. They spent money on that, if not time on that. Take your own pictures. All right. Okay. So it's like, so who fail to obtain prior written authorization from the originating REL or other appropriate party with a legal right to reproduce and display such images. So please don't copy images out of the MLS because the previous agent took some really cool pictures. They may have spent money for them, but it doesn't matter. It's against the rules. Our MLS has very specific rules for copying that information. It is not okay. All right. So please don't do that. Okay. Now, if you go paying something, now you're the person that went and paid somebody to go take those pictures. How would you like it if, later on you find out somebody else used your pictures rather than going and getting their own? I mean, maybe the listing didn't sell. Maybe you're probably angry about that. You're sure not going to be happy when they use your pictures. So if you are that person who wants to use those pictures, get something in writing from them that says that it's okay. All right. Everybody good with that? Any questions on any of that so far? Yes, I have a question. Okay, here we go. Do we have to be concerned about photographers having or not having an FAA? George, you always ask really good questions. I know it's a rhetorical question. I know you know the answer to it. The answer is absolutely, okay? You may not just fly around people's houses with drones. We did a whole thing at the SDAR Expo about 2 years ago. We had a huge drone company come in and talk about that. And you're absolutely right. You need to work with people that are approved by the FAA. I recommend against self-help. And here's part of the deal. So like I'm at home and Linda starts screaming that, there's a drone flying out in our front yard. I mean, she's looking for weapons, right? She thinks it's time to go play skeet. Okay, so please make sure that you have, of course, then we have the unlawful discharge of a firearm, that kind of thing. But it gets people upset, right? We got drones flying around the neighborhood. They don't know what you're looking at, and so we're just into that age where those things are going to be happening out there. You can buy them at Costco for $500. So the answer, of course, George, is yeah. You need to make sure they have an FAA license, and those rules are really complicated. We had I actually kept the handouts from that seminar that we did at Expo. Expo is awesome, by the way. May 1st, coming up, May 1st, you've got to go to Expo all day Friday down at the convention center. We're the biggest thing happening next to Comic-Con, right? So you got to go to that, folks. It's just, and I think you're free. I don't think they charge you to get in, but you definitely need to be going to that. But God, there's so much stuff. So no, absolutely, George, you're right. Absolutely. Make sure they have an FAA license for doing that. Do you have to get any permission from surrounding neighbors? You know what? I would. There's that argument that says that do you need, it's better to beg forgiveness than ask permission. I don't know. It's going to depend on a lot of different things. If you're doing a drone on a townhome, you're definitely close to the neighbors. If you're doing a drone in Rancho Santa Fe, where the property's on 5 acres, you're more than likely to be trying to, photograph the entire property. You're probably going to pick up a neighbor's property. I would definitely consult with legal on that, consult with your broker on that. The way that we're going in our industry is more and more exposure. And so the answer to your question, yeah, definitely FAA approved. Definitely, I would probably, tell the neighbors that you're going to be, taking pictures. That's probably not a good time to be sitting out by the pool if they don't want to be photographed. And make sure that they understand that you have something from them, an email or something that says they understand you're doing it at 5 o'clock on Thursday. And if they have a problem with it, they need to let you know. Okay. All right. Any questions about any of that? Boy, that was good. I look at this material and I just go, how am I going to make paragraph 9 and 10 interesting? And at the end of the day, it's fascinating what we do in our business. And these are the kinds of questions that people call me on. And sadly, these are the kinds of things that attorneys call me on and say, hey, you know what? I need you to handle a case where this happened. And so let's not be that case. Okay. I like going to court. Linda will tell you, it's always good for me. It's just never good for us in real estate in our industry. Most of my cases settle. I don't know if it's a statement as to how good I am or not, but I can tell you, not pleasant. Let's try to avoid it. I don't want to see anybody being in harm's way. And if you have any questions, anything I can help you with, please let me know. Every transaction that I do, we're doing a lot of transactions. I think we sold 3 houses yesterday. We do a lot of transactions, and every time we do one, it's a learning experience for everybody, myself included, right? Some things I know, like the other agent sends me an email that says, here's a copy of the fully executed contract. And I go, oh, good. Have we closed? It's not a fully executed contract, folks. That's a term of law. That means it's closed, it's recorded, it's settled, whatever. It's an executory contract, okay. So that's one of those little things I kind of like my little pet peeve. I get my ears up. So be good out there, behave yourselves, take good care of each other, and God, learn as much as you possibly can. Any other questions about any of this from anybody today? I want to make sure I'm covering it. George, you're wonderful as always. I appreciate you. Seeing no other questions, I'm going to go ahead and I'm going to take us back to our original PowerPoint, which at least gives you my contact information. I'll leave that question up here in the corner. Here's how you get a hold of me. Resume the slideshow. This is going to create havoc on me for tomorrow night. Anyway, there you can see it. Or tonight rather. I'm teaching a class this evening, so I got to reset all my parameters. Okay. All right. Seeing none, I want to thank you all for being here today. I'm excited to hear. Hopefully you'll get in there tomorrow at 10 o'clock when we have our Zip Forms webinar. And then at 1 o'clock, we'll be doing our RPA. And I don't even know what paragraph we're on, but I'm very excited to get to see you then. So thank you all for being here today, and I wish you the very best. Take care for now.